Hello everyone, Jai Hind and welcome to the platform of SRIRAM's IAS once again, and in today's session we'll be discussing about Directive Principle of State Policy from Article 39 to Article 43. Alright, that would be the sphere of discussion in today's session, and we have already covered the fundamental rights in our previous sessions. Already we have already covered fundamental rights, and from today onwards in the next two sessions we'll be discussing about the Directive Principles of State Policy. But before moving ahead, let me tell you that we are offering you with 1:1 free mentorship at SRIRAM's IAS. Now, this mentorship is available to everyone. अगर आपको कोई भी problem है, कोई भी doubt है, कोई भी discussion आपको करना है relating to your UPSC preparation, so then what you can do is आप जो description में there is a Google form and also in the comment box you can fill it up, and our mentors, जो trusted mentors हैं, they will get in touch with you and they will guide you throughout for your successful journey for the UPSC Civil Services. Okay. Now we are talking about the directive principles, and what are the directive principles? So in the words of Dr. B.R. Ambedkar, he said that these are just like the instrument of instructions that were given under the Government of India Act of 1935. Now, when we talk about the constitutional framework, they find their place in in part 4 of the Constitution from Article 36 to Article 51. They are non-justiciable. Alright, unlike the fundamental rights, they are non-justiciable. That is, that they cannot be enforced through the courts, and they provide the blueprint for establishing India as a welfare state. At the same time, they lay down the foundation for the economic as well as social democracy in India. Now, these directive principles have been taken from the Constitution of the Ireland, and also from the Ireland have taken it from the Spanish Constitution, but at the same time, the socialist ideals and the economic justice that is given under Spanish Constitution and Soviet Constitution respectively have been utilized in framing the directive principles of state policy that we have in our part 4 of the Constitution. Now, over here, it is very important to note that the fundamental rights lays down the political democracy in India, but at the same time, the directive principles ensures the social and economic democracy or the justice that have been inscribed in the preamble to the Constitution of India. Now, we have classified the directive principles into 3 different segments. Although there is no such classification that is given under the Constitution, but we classify them for our own understanding. Alright, they have been classified as the socialist principles, that is, which gives us the economic equality as well as the social equality or the social justice. Like for example, we have articles from 38 to 43, Article 43A as well as Article 47. Then we have the Gandhian principles that have been incorporated in the Directive Principles of State Policy, Article 40, 43, 46, 47 and 48, that provides for rural economy and also the village self-sufficiency and the self-governance. Then we have liberal intellectual principles which have been added. Like for example, we have Article 44, Article 45, 48A, 50 and 51. These are the articles which provide for the individual rights as well as the environmental rights that are there. Now, in today's session, in the first half of the directive principles that we are discussing today, we'll be discussing about the socialist as well as the economic and Gandhian principles that have been laid from Article 39 to Article 43. Now, the first article is the Article 39 that lays down various economic justice or the principles for the economic justice, like for example, equitable distribution, and over here it prevents the wealth concentration in very few hands. Alright, at the same time, it also provides for equal pay for equal work, where gender and social parity have been laid down. At the same time, it provides for the right to sustenance and right to livelihood, as well as it provides for the child protection against the exploitation as well as abuse, and at the same time it provides for safe working conditions for the workers as well. So over here, this particular right, or the directive principle under Article 39 provides the economic justice that forms the basis of or the foundation of the political freedom that we have in India. Now, when it comes to the several landmark cases where we have seen the Article 39 to be pronounced by the Supreme Court, so we have the first case that was there in 1970, Chandra Bhavan boarding versus State of Mysore, where it was upheld that there would be equal pay for equal work. At the same time, in 1981, there was a case, Air India versus Nargesh Mirza, where it was upheld that the gender discrimination violates the equality that has been provided by the fundamental rights that are there. And then under MC Mehta versus State of Tamil Nadu in 1996, there were the constitutional provision or the constitutional mandates, protection that have been provided for the children or the child workers that have been that have been laid down under Article 39E and 39F. So these are the remarkable cases when it comes to Article 39. Then Article 39B and C, we have already spoken about when we were talking about in the fundamental rights. Now, when it comes to Article 39B and C, Article 39 says that the material resources, they will serve the common good. At the same time, Article 39C is about prevention of the wealth concentration in few hands. Alright, over here in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal in 1983. Alright, this was a time when the Indira Gandhi was there and she nationalized various coal companies as well as she nationalized the banks as well. This was a phase of nationalization. And over here, the Supreme Court have ruled in this particular case that the nationalization was upheld in the public interest. At the same time, I have told you about the Ayar Kaulo case versus State of Tamil Nadu in 2007, where it was laid down by the Supreme Court that any law that violates the basic structure, it cannot be protected from the judicial review, and the judicial review will lie wherever the basic structure has been hampered or it has been taken away. The next article is Article 39A that provides for equal justice and free legal aid. This has been added by 42nd Amendment Act of 1976 and it has been implemented through NALSA, that is National Legal Services Authority, and the Legal Services Authorities Act of 1987. Over here, a prominent case was Hussain Ara Khatun versus State of Bihar in 1979, where the right to free legal aid was made an integral part of Article 21, that is right to life and personal liberty. So right to free legal aid is basically an inferred right under Article 21. The next comes Article 40, that is about the village panchayats, and this upholds the Gandhian philosophy or the Gandhian vision of the self-sufficiency or self-rule in villages, that is Gram Swaraj. Alright, when you talk about the village panchayat, it says that there will be, or there is a constitutional directive where the village panchayats will be organized as self-governing units, and over here, after this was the fundamental right, directive principle under Article 40. Later on, there was 73rd Amendment Act that was passed in 1992, and when we talk about the 73rd Amendment Act, over here, it institutionalized the grassroots democracy, and the Panchayati Raj system was given a constitutional authority, alright, by the 73rd Amendment Act of 1992. The next article is Article 41 that provides for, or it provides a mandate for certain special conditions where we have unemployment, where we have old age and disability. So they have the right to work, right to education, and for right of public assistance. So that is within the economic capacity of the state shall secure the right to work, education and assistance. And using this, we have the Manrega that was passed in 2005 that provides for the statutory right to work, as well as we have Article 21A that provides for the right to education, right to primary education, that was added by 86th Amendment Act of 2002. Now, when it comes to the prominent cases involving Article 41, so it was in Unni Krishnan versus State of Andhra Pradesh in 1993 that the Supreme Court laid down that the education had been elevated, or education was given a fundamental right status under Article 21 as well as Article 41. So over here, the fundamental right status or the right to education was said that it is the integral part, because how you will have right to life and personal liberty if you are not educated enough. So in Unni Krishnan versus State of Andhra Pradesh, this was done, and later on we had the right to education that was provided as a fundamental right under Article 21A. Alright, then we have Olga Tellis versus Bombay Municipal Corporation, the case that was passed in 1985. Over here, the right to livelihood, it was said that it is derived from the common interpretation of two or conjunction of two articles, that is Article 21, right to life and personal liberty, and even Article 41. This was the landmark judgment where there was expansion to the right to life and personal liberty. Next articles come is the Article 42 that provides for just and humane conditions, working conditions, and it provides for the humane conditions as well as maternity relief as well. Both the conditions have been laid down. So there have to be safe working environment and also reasonable hours, that is, or there would be a fair treatment that would be provided, that is that there would be human conditions for the workers that will be provided, and also it provides for protection and benefits for the working women, that is, or the working mothers, that is maternity relief have been provided. And over here for the just and human working conditions for the workers and for the maternity relief, there had been certain laws which have been incorporated, like for example, there is Factory Act in 1948, Maternity Benefit Act in 1961, and Code on Social Security in 2020. And in Municipal Corporation of Delhi, MCD versus female workers in 2000, it was pronounced that the maternity relief is recognized as, or it is a constitutional right as per Supreme Court of India. The next article is Article 43 that provides for that, or it obligates the state to provide, give or secure a living wage, ensure decent standard of life, provide social and cultural opportunities, and also promote cottage industries in rural area. And that is why you know that we have Khadi Village Industries, KVIC, that was established in 1956. All right. So there is, or it is again on the Gandhian vision where we have, or he has the emphasis on decentralization as well as self-reliant rural economy. All right. The next article again was added by 42nd Amendment Act, and this is Article 43A, where it is there would be workers' participation in management of the industries, and it was added by 42nd Amendment Act again. And over here, it has been implemented through Works Committees, Industrial Disputes Act, and CSR or Corporate Social Responsibility based participation as well. In Balco Employees Union versus Union of India in 2002, it was said that this is essential but non-justiciable. Alright, now when it comes to the directive principles of state policy, there are certain implementation challenges which are when it comes to the directive principles, and that is because of lots of things. Like for example, when it comes to the money, alright, when we are talking about social and economic justice, that requires financing, that requires money to be there, alright, then only we can provide with the economic justice specially, and also through economic justice we can provide with the social justice. So there are financial implications and financial limitations. Welfare measures, they are constrained by the budget realities. At the same time, they are non-binding in nature. The directive principles, they are just like guidelines to the states, alright, so they are of non-binding nature, and that is why there is weak enforcement as well. There is policy reversals while the government changes, and that creates the political inconsistency as well, and there are judicial conflicts where historical tensions were, or it was between the directive principles and fundamental rights, but it was resolved in 1973 when in Keshwaran Bharti case, Supreme Court said that the fundamental rights and also the directive principles, they are not in conflict but they are in harmony. Alright, so over here we can see a comparison between directive principles and the fundamental rights. The fundamental rights are justiciable. They are they provides for the political democracy, and they are enforceable by the courts. Alright, at the same time they have limited protection and they are negative obligations on the state. Whenever you will read the articles in the fundamental rights, that will start from the state shall not. Alright, the state shall not, that means it is a negative obligation on the state, what the state cannot do. But at the same time, when it comes to the directive principles, they are positive obligation. The state shall provide, the state shall. So these are the positive obligations on the state. However, they are non-justiciable and also not enforceable by the courts. They provide for the social and economic democracy and can be enforced by the legislature and the executive by framing certain laws. If there would be a law that would be formed, like for example, I gave you the example of Manrega, all right, or I gave you the example of NALSA as well. So whenever there are the laws that are framed, so that will lead to the implications and the implementation of the directive principles, but otherwise they could not be enforced by the laws. And over here, when it comes to the protection or the amendment, they could be amended easily. All right, the fundamental rights, they could not be amended easily because they are, or some of the rights, they are basically, they guarantees the basic structure of the constitution. But at the same time, directive principles can be amended easily. All right, in Minerva Mills case, it was said, again, it was reiterated that the fundamental rights and directive principles, they are in harmony and not in conflict with each other. Now, these are certain landmark judgments. In 1951, in state of Madras versus Champakam Dorairajan, it was said that the fundamental rights, they prevail over the directive principles of state policy. However, in 1973, in Keshwar and Bharati case, it was laid down that there is harmony between fundamental rights and the directive principles. And later on, in Minerva case, also in 1980, it was recognized that there is a balance, there is a harmony between the fundamental rights and the directive principles, and basically this balance that exists between fundamental rights and the directive principles is basically a basic structure. And later on in 1993, in Unnikrishnan versus state of Andhra Pradesh, it was said that the directive principles can give rise to enforceable fundamental rights. This was laid down. All right. Now, when it comes to the governance, you can see that these directive principles, they align with the sustainable development goals as well. All right. So, when it comes to the sustainable development goals, we have different commitments which relate to equality, it relates to welfare and even justice. So, over here, when it comes to equality, all right, welfare or justice, that is what is provided by these directive principles of state policy. In the housing and health, you can see we have different schemes. We have PM Awas Yojana, Ayushman Bharat scheme, that is there. Then for the employment, we have Manrega as well as Skill India mission, that is there. And for the social welfare, we have Beti Bachao, Beti Padhao, and also we have Poshan Abhiyan that we are running. So ultimately, all these different developments and the programs, they are basically facilitating the directive principles which have been laid down by the Part 4 of the Constitution. And these programs demonstrate that we have Constitution which is of the living nature. So that would be all in today's session. But let me tell you that when it comes to the directive principles of state policy, they are basically the social contract which provide for or which represent the constitutional commitment to the social as well as economic justice. All right, it provides for the economic equality where the ideals have been transformed into living reality. At the same time, it provides for the comprehensive justice. Along with fundamental rights, the directive principles gives us political, social and economic justice that is enshrined in the preamble of the Constitution, and they are positive duties towards the citizens' welfare and their development. So again, when we talk about these directive principles of state policy, the fundamental rights, on one hand, they are negative obligations, but directive principles, they are positive obligations which have to be taken into consideration wherever the state is planning for any policy or laws or regulations when it concerns the citizens of India. All right, so that would be all in today's session. Thank you very much, guys, for joining me over here. That would be all. Thank you. Bye-bye. Take care. Jai Hind. But do not forget to like, share and subscribe to our channel. Thank you.